Hello, and welcome to our In the Know Legal Education series. Today, I want to talk to you about a very important aspect of contract law. We teach you what your contract is, what it does, what the language means, and how to customize it, as well as important next steps. But there are a lot of things that happen before you enter into a contract, and we want to talk about some of that with you. The concept I will be discussing has a name, and it is called parole evidence. Now, you may be wondering why I am talking to you about anything having to do with parole. Well, parole is a French word that literally means word or speech. While originally it referred to verbal speech, in the medieval times, they used the word parole to refer to legal pleadings. So, it actually refers to both verbal and written correspondence. Here, we use it to relate words outside an agreement. The parole evidence rule limits the extent to which discussions or writings made prior to or contemporaneous with the signed written contract can be admitted and considered part of the signed written agreement. What? I know. Now, let's talk about what a signed written agreement is. It is a totally integrated contract, which is considered a final expression of the writing, and is something that is intended to include all of the details of the parties. It is not, for example, a proposal you send out to your client or email discussions. So, all the stuff you say prior or contemporaneous to signing that totally integrated agreement or contract cannot come in to contradict or supplement any of the terms in the agreement. Okay, let's say I agree I'm going to make a custom-made chocolate cake for you and deliver it to you March 1st. You are going to pay me $50 for the cake. Let's say I deliver the cake and you don't pay me. I wouldn't pay me either because I cannot make chocolate cake. So now I not only demand my $50, but also a $25 late fee since you didn't pay me in time. But if my contract said nothing about a late fee, then any evidence of that late fee is parole evidence. We may have chatted about a late fee over email, but it wasn't in the agreement. Now, let's talk about another service context. What if in our negotiations, I say, hey, don't worry, you can call me anytime, text me, or whatever between our sessions. But the contract says there will be absolutely no communication between service provider and client between sessions. Client may not communicate with the service provider. Well, if that is the final contract, it erases everything that was said before, and you won't be able to bring in evidence of that prior discussion of your being able to contact me. The theory is, if you wanted this as part of your agreement, it should be in the agreement. Now, there are some exceptions. If there is an actual defect in the contract, you can bring in evidence of that defect. Or if the contract does not take effect unless some condition is met, for example, I will only buy birthday cake from your store on Saturday if you have chocolate cake delivered that day. Then those prior discussions can come in. Why? Because while we don't want anything to change an existing agreement, we will allow evidence that shows that the agreement itself is defective. Like if I duped you into signing a contract with language that I hid, that is fraud. And but for my duping you, switching out what it says, you would not have entered into that contract. Absent fraud, mistake, illegality, or conditions, we assume the parties are of equal bargaining power and can read what it states and understand what is and is not in there. Now, don't get parole evidence confused with stuff that comes after you enter into a contract. That is different. That is called a modification, which in fact is represented by one of our templates, an amendment to a services agreement. Modifications are allowed, and that is when circumstances change in which the actual performance due under the agreement changes, like the scope of services or the price involved with the new scope of services. This happens and is normal. You just want to make sure it is clearly spelled out whether you require the modification to be in writing and whether both parties have to agree to it. So, there is a little contract law to help you understand the before and after of your contract. I hope you enjoyed this education series and that you feel a little bit more in the know.